has started. And now to Chair, Councillor. Oh, in fact, before we do hand over to any chair, can I have election for chair? Can I have nominations for chair?
Councillor Buxton.
I'll agree. Cool. Okay. Happy with that? Yep. So welcome tonight. Thank you all for returning after the adjournment. We will be restarting the meeting afresh. So I will begin with introductions. I'm Councillor Lester Buxton. I represent Crouch End Ward. To my left,
Councillor Victor Costa, member of the Highgate Ward.
and to my right.
I'm Councillor Kolshika. I'm in Northumberland Park Ward.
Thank you. We'll introduce officers, starting with Yisrael.
Israel Greenberg, legal advisor to the subcommittee.
Thank you. The clerk
Nazia Chowdhury, clerk to the subcommittee.
and the licensing officer. Okay, so speakers to be confirmed. Can I ask the applicant to speak, Craig? Thank you. Supporters of the application, I believe we have some joining online. So Councillor Small.
Yeah, here, Chair. Hello.
Thank you. And do we have, there's a Gwendolyn, will you be, is that one of the, that's not one of the ones I have noted down. No, that's an observer. Cool.
Is there anyone else through you, Chair? Is there anyone else registered to speak? I don't think there is actually. So I think we've only got Councillor Small, who is a registered speaker. I can't see anyone else.
Cool.
Unless you otherwise.
It's not a problem. Police representation. So I think there's a few of you here. Can we start?
James Rankin, representing the police.
Yep. Do you want-
You've done I'm the licensing officer. Police Sergeant Dan Jones, licensing officer.
And I'm PC Mark Craig, central licence.
Thank you. And now the licence holder, Mr. Dance.
Licence holder,
James Cairns.
and I'm counsel. I'm representing the premise licence holder. I'm David Dance.
Thank you. We'll move on to item 1, which is filming at meetings. So please note this meeting is being recorded and will be available for public viewing. Apologies for absence.
Apologies have been received from Councillor Peacock. Councillor Buxton is substituting in.
That's me. Item 3, urgent business.
No urgent business registered, Chair.
Okay, any urgent business?
I did make an application for an adjournment, but I don't need to.
We can deal with that now. What would you like the case for the
Sorry.
Yeah, sorry.
Declarations of interest.
Declarations of interest with you first. Okay, sorry. Declarations of interest, and then we'll move on to the adjournment. Any declarations of interest?
None to declare.
None to declare. Okay, right. Now we'll move on to the request for adjournment. On what grounds?
Yes. We require more time to prepare for the hearing. We were given further information last week. And in fairness, we've not been able to address all of it. I have done as best as I can, and I've sent over a further grid this afternoon. But in fairness, I haven't had the opportunity to go through all that with the client, the premise license holder. We've got some video clips that we would like to share and produce and get them together, and we've not been able to do that because technically we don't have the same resources as the Met Police. But obviously that's going to be quite important too. And so in relation to us having time to be ready to present our case, but also I would raise the point about timing because it's the evening, but I know that everyone's already probably had a day's work. And I'm conscious that certainly that I'm aware of, we've probably got ourselves on the new information, all the CADs that have been produced. I think I've got at least 38 observations to make on the Christen CADs, which are going to be at least probably a couple of minutes each one, which will take me probably an hour and a half. So the reality of it is, given that I think we've been served with over 500 pages of documents, we've tried to bring it into focus, but even in focus, there's about 40 points that we need to make and go through the grid, and I think that's going to take at least an hour and a half. So I'm conscious that Mr. Rankin and I will need both, and the environment of the applicant will need time to go through that. It's there's some serious allegations that we are making against how the papers were presented and so on. And we want to go through it and cover it and make sure it's very clear how our case is put. And we just haven't had the time to prepare to be able to respond in a meaningful way. If we're rushed and pushed to it, but we think that that would be unfair, and that I'm just conscious of that. So it's about timing, preparation, equity of arms. And I think in fairness to both parties, we don't want to rush it. I'm conscious that I did suggest in my email that we might perhaps, this might be a suitable case for a daytime hearing rather than an evening hearing, so it doesn't need to late hours. But that's a matter for you. That is my submission, Chair.
We'll take representations from other parties. Is that correct?
Chair, perhaps I could ask if you can make sure it's clear. Number one, which information is the point is being taken in relation to, and number two, which, if any, specific rule or provision is being raised.
So I think, yeah, can we have it? So I think up until page 29,
wasn't it?
first of all, I should make note that we are ignoring the letter from Capital West that was agreed to ignore last time. Make that clear for the record. Page 29 was pretty much the papers that we had last time. Since then, the CAD reports, which is just the raw data provided by the police, that was provided by the police from 31, which you referred to in the last meeting. So that goes to page 600 and something. And then there are additional papers which include additional CAD reports in additional papers 2. Am I right?
I think.
Yeah. Which include CAD reports, but also letters from the police, PC Denham, and then also additional papers 3, which is your submission, Mr. Dadds. So for clarity, which papers are you saying are that you haven't had time to review?
Yes, thank you. So just so that I can tell you what I've had, we had, so, and I'm quite happy to hand up if need be, because I've done a quick analysis of what I had and what I didn't have. Because when I received the additional papers on the 23rd, I was then able to look at what we have already, because I produced some last time, if you recall. So I know that we didn't have 1, 2, 3, 5, 6, 7.
So these specific CAD references?
Yeah, so we didn't have those, so that's new that I had to deal with, but that was on the 23rd of July. Okay. So I've been able to do that. It took me, I can tell you, it took me 10 hours to go through the raw.
Yeah, that was your submission.
Yeah, so I did that.
Yep.
And then last week, I think on Thursday, we had another set of papers, which was about 160. There was some duplication, but about 160. And I spent this afternoon 4 to 5 hours going through that this afternoon to complete the grid. But what I haven't had is the time to go through them fully with my client, and also to look at the CCTV and the stuff that we want to support that. So I have actually done my best to try to do as much as I can. And over the weekend, I wouldn't have been able to do it because I had 2 hearings yesterday, which I was preparing for. So I've used all the time available to me. So I'm just saying that's the information. In relation to the regulation, I'd need to look. I think it's either 14 or 19, I can't remember. But there is a provision that allows for adjourn. It's in the public interest to do so. I ask that it's in the public interest to do so, to adjourn. I'll get the.
If you can get the
It's only because I couldn't log on to the my laptop when I came in, so I'll have a look.
So we just need the specific rule.
I think we used it last time.
I don't think, I mean, in the hearing itself, we didn't ask for a specific.
Well, I wonder if Mr. Dadds might be referring to rule regulation 12 of the regulations.
Which is?
Would you like me to read it, Chair?
Yes, please.
Subject to Regulation 13, an authority may adjourn a hearing to a specified date or arrange for a hearing to be held on specified additional dates where it considers this to be necessary for its consideration of any representations or notice made by it.
And that's right.
Okay. So do we hear from other parties that might object to that adjournment?
Yes.
So is there other parties that object to that adjournment? Mr. Rankin?
I object in the strongest possible terms to it. This will be the third adjournment of the matter. The original hearing was listed for the 16th of June, and at Mr. Dadd's request was adjourned. It was then relisted on the 7th of July, and then matters out of everybody's control. One of the councillors was resident close to the premises, so that had to be adjourned. But you'll recall last time, on the 17th of July, we went through most of the hearing. And it was only towards the end of it that Mr. Dadd's requested an adjournment. And we served on him all of the papers that he requested. They were served on him for the purposes of 17th of July. They were served the day before. But in fairness to us, it was a late request. So we served as best and as quickly as we could. This time, we served the papers that Mr. Dadd's asked for last week on the Thursday. Now, Mr. Dadd says, well, I was busy with 2 other hearings. That's bad luck. What busy solicitors should do if they are overburdened with work is that they should brief counsel to do it, and they should represent Mr. Cairns, and they can take instructions from Mr. Cairns, they can get the brief in apple pie order. But what Mr. Dadd has done is kept the brief for himself, and then come before this committee and suggested that through overwork and over provision of cases, he's been unable to apply himself to this case. That's bad luck.
Any other parties?
Can I respond, please?
In a moment, I'm going to take objections from other parties. Councillor Small, Councillor Small's the only registered speaker. Yes.
Hi, Chair. Thank you. Yeah, can I just stress there was a public interest argument that was being put forward on the agenda. There is another weight to this, which is given the sheer scope of the evidence. The sheer scope of the arguments put forward in the papers. There is a strong public interest argument to needing to proceed based on the impact that it is having on residents, and that the licensing committee have been repeatedly asked and have been repeatedly flexible to try to proceed as best as possible to suit the parties around the table. And I just want to add in to the parties around the table the voice of residents as their representative councillors of the severe impact that the continuing operation of the licence holder is having on them.
Thank you, Councillor Small. Mr. Dadds, and I'll come back to you, Mr. Rankin.
I think it's only fair that I should respond because there appears to be some criticism of me, and I think that's right that I should respond. Firstly, as you heard, we were served very late, the day before on the 17th, hundreds of pages of documents, which I managed to deal with before, as much as I could before the hearing. And then we heard more representations, which I then sought the adjournment. On the 23rd, we received yet again another hundreds and hundreds of pages of documents, which you've just heard I've spent 10 hours on preparing. You'll also know that I told you last time I was here, I was away for a week. Obviously when I've got back, I dealt with the papers that we were served on the 23rd straight away, and I was able to produce those and deal with those. The late papers on Thursday, and I think they came in at 3 o'clock in the afternoon, 160 pages. I'm no counsel sitting around waiting. And then I had a case on Friday and 2 cases on Monday. And you know, with the greatest respect, Mr. Rankin may not do this, I don't know, but I'm actually those 10 hours work and the 5 today and this hearing I'm doing pro bono. I'm not charging. The client is run out of fees. So in effect, I'm here on a free basis. So we can't instruct anyone. There's no one to instruct, and I'm coming back again for free. I think it's in the public interest to do so. So in relation to the points that I make, there's two. One, in relation to preparation and being able to respond. Some of the technical stuff like the CCTV and all that we can't do. My client needs to do that. They need to get that together in a format that can be given to you.
Can I, on that point, why, I mean, that has had, we've had, as we've discussed, numerous hearings.
It's to do with the Thursday material that's
It's-
through, yeah,
So the Thursday material is
Right.
additional CADs,
for July, yeah.
is additional CADs and
And we have CCTV for July because it's 30 days, so we are able to go back. Because Mr. Rankin, if you remember, said last time, well, no, how it is, it's, you turn up, it's already finished or something. So we've got some CCTV of certain days that have been reported in July that we know that nothing's happened before, the police have turned up and there's something there. So
Yeah.
it's technically getting that together.
so, Mr. Dat, on that point, page 25, the original CAD report that you queried at the last meeting
It goes
has
up to the third.
3rd of July.
I'm talking that it goes after, that the matters.
But so within the 30 days, we had that meeting, what, on the 17th of July?
Yes.
Is that correct, Clark?
Yeah.
17th of July was the last meeting,
Yes.
yes? So why was that CCTV not applicable to the CADs on the 3rd of?
I'm pleased you've asked because I think I need to clarify to you what I had available to me. So when we were here on the 17th, I had all the CADs up to the 3rd of July.
Yep.
I dealt with it because I got served, I think it was the date or the 17th of July. I got the information the day before, so we couldn't produce any of the CCTV. But the CCTV that we want to produce relates to the matters arising after the 3rd. I think I've got it here. So they relate to matters, let me tell you the dates, regarding from the 6th, 14th, 15th, 23rd July.
So these are, where are these referred to in the papers? These are referred to in
The matters that were served last Friday, last
So,
Thursday, late.
page
numbers, please.
So
I
I understand, is this in Miss Denner's report or the CADs?
the CADs,
It's in the CADs.
just relate to the CADs.
So I don't have the printouts.
Okay.
These CADs, i.e. like the transcripts.
Yeah.
Sorry, I'm not a police officer. I'm not gonna have the exact terminology for what these are. So on the
Last
last Thursday, 160 pages were submitted.
yeah.
There were 145 pages of CADs and then 15 or so pages of a letter from PC Denham explaining some of the earlier CAD references. So we have 2024, we have some in 2025.
Two lots, there were two letters.
Yeah.
One was in relation to clarification.
But so
One was in relation to service and new evidence. And in the relation to the service and new evidence, they related to matters
so
of.
Mr. Dyer, let's try and get to the bottom of this point. So the letter that Miss Denham, PC Denham submitted had incidents up until the 3rd of July, which was what was queried in the original report.
Yes.
So what I suggest is that those CADs which were submitted up until page 145, so those are the raw CADs that were submitted last Thursday, be disregarded. So obviously with the police, I understand your point. I'm keen that we sort of move this on in.
You're going to have to hear me, I'm afraid.
I'm absolutely, I'm going to hear you. I'm going to try and find a halfway point that we can hear this properly and effectively. So the CADs up until I think there's some police reports in the additional papers that were submitted by the police. What I suggest is that we disregard those raw CADs and the police reports. So that is up until page 144. I obviously take the legal advice. The letter, page 145, which PC Denham wrote, is an explanation of all of the incidents. Correct me if I'm wrong, PC Denham. All of the incidents that were submitted on page 25, which you queried at the last meeting. But obviously, all those incidents
I've prepared.
you have had for a significant amount of time. I don't think in this there were two letters.
Yeah, there was two,
So-
letters, 31st.
So the second letter, which is all events that have happened since the 3rd of July, again, we would disregard. Obviously, we as a committee might want to ask what has happened in the past month or so, as would be a standard
Yes.
licensing question. But
Could you hear from me on that point, on that suggestion?
okay, yeah,
Whilst I acknowledged you're attempting to find a way through, and up until that date, I can tell you up to the 3rd, I'm prepared.
Mhm.
So I told you about the tenants, that I've done that. But the information that was served, we know, for example, we don't want you to exclude it, so.
Yep. I'm talking about all events after the 3rd of
yes,
July.
We don't want that to exclude. So for example, on the 6th of July, in the CADs, it makes it clear that there was violence against the person recorded as a call on the 6th of July. But when the police attended, it was no crime. And ultimately it was classified as an Oaks call, and it went through the description. We've gone through the analysis of the whole of July, and there's evidence there that we want to adduce, because now we have it. There are two false, so there's another one that says a false or malicious call on the 14th of July. We've got CCTV of the other, like for example, there's one here about noise on the 23rd of July at 3 a.m. We've got CCTV to show that it was closed at 2:41 and the alarm was installed. So this is evidence to show that actually those matters we reported in July, we've got evidence to show that they're either hoax, malicious, not true. And we should have the opportunity, because I know what's going to happen. And Mr. Rankin's already alluded to it last time. He's going to say, but when the police arrive, it's all come to an end. So we've asked for this information. We want that we've had the information. We haven't had time to prepare and do all the CCTV and respond. You need to hear this up-to-date information. We want it included. So we don't want you to.
So, Mr. Dan, I understand that. If
You understand?
I understand the point. If we adjourn the meeting to a later date, I will fully expect the police to then provide as most up-to-date information, which will include calls that you have not been able to scrutinise. Off the top of my head, I can't tell you what you've got.
I've got it.
What's the latest CAD reference that you have?
It
As in-
is the date you mean?
Yeah.
It's the 27th of July.
27th of July. So that was last week. So, and obviously that was the day before the
31st, I think.
31st. Okay, that was 2 or 3 days before. So
You're always going to have,
we're always going to have that, Mr. Dads.
but here, this is really critical information. for
And
us,
why is-
because we can show there's hoax calls, malicious calls, false calls, and we should be able to show that to you. The reason why is that.
Was that the case in previous?
No, it's not, because
So
the reason why is that we do have the time and we have saved the CCTV and we've got our logs. So we're better organised and prepared now than we were previously. And also, this comes down to a very serious point, Mr. Chairman. We believe that some of the calls, and we've asked the police another number of questions, potentially could be seen as hate crime, because some of these vexatious calls, malicious calls, are against a protected characteristic group of the community, and that it's in effect a hate crime to make malicious calls in that way. And I think that is important. We want to make sure we get a fair hearing.
absolutely understand. Councillor Da Costa has a question.
So I've got a question. I understand your argument that you say there's evidence of malicious calls, but if we're disregarding the existence of those CADs, why are you having to make the case that they were malicious? If, as a subcommittee, we say we disregard anything that happened after the 3rd of July, in our view, it didn't happen, there were no CADs, there were no call-outs. Why are you still trying to make that case?
Well, the reason why, it's a really good question, and normally I would be quite delighted for you to, but here, we have 40, roughly, I believe the number is 38. So I have 38 that I can go through where it's no crime, the police turn up, no matters arising. I know there is evidence here we can show that it's malicious, falsehood, didn't happen. And I know that Mr. Rankin will argue the point which he argued last time, is that because when the police turn up, nothing's occurred, but it doesn't mean it hasn't happened. I want to use the evidence of the last month to show that actually in the month, what has happened, we've got the CCTV, we can show police turning up with 4 cars and inside behind in the premises what is occurring before as the call is being made to the police. So we can show that, and that's going to be important for you to see what's happened the last month, how that is, because that will have an effect of what the evidence is, I say, on the previous calls when the police turn up and nothing's there.
I think,
You see the point I made?
Yes, I can see the point. I'm trying not to slip into asking you questions on the hearing itself, so I need to.
And also timing, remember, I've talked about timing.
Yeah.
Fine.
But my worry is, and Israel, I appreciate your guidance. If I ask the question, you tell me off if you have to. My issue is, I understand you're trying to say in the last month X has not happened. These things haven't happened. You've got proof. My challenge back is, but then are the CADs that happened previously, they have happened, and you have evidence of that, and you haven't compiled that, or are you saying in the last month the behaviour has changed so drastically that you want to show evidence of the drastic change in behaviour? I'm trying to understand the
What we don't have historically after 30 odd days, 30 days, we don't have recordings. So matters complained of before, say, June, we don't have any CCTV. When we were provided all the Chris and CADs in, I think for the day 16th of July, also we didn't have that opportunity to go back and compile and look at CCTV because of what happened last time and because of the representations from Mr. Rankin, the suggestion that even though it's not a crime, it's been no crime, doesn't happen. So on that basis, we are preparing our case to show, well, actually, look what's happened in the last month. Look at the calls that happened. It hasn't happened. It's no crime and it hasn't. Here's the CCTV. So to rebut that argument made by Mr. Rankin last time. And I think that's very important for us because in addition to that, we believe that some of these calls are relating to hate crime because they're against the protective characteristics of the travelling gypsy community.
Can I just ask a question?
Councillor, yep.
Can I ask the legal? It's becoming a personal thing between the two representations, and I really am wondering: is the decision, having listened to both representations, is that decision sitting with them, or is it a decision that the committee has to make about whether we adjourn or we don't adjourn?
The decision whether to adjourn or not to adjourn be for the committee.
Could I briefly respond?
Mr. Rankin, yep.
It makes no sense. If he's saying, well, we were served with the papers on the 16th of July, our CCTV goes back 30 days. If his allegation against my officer, which were serious allegations, that she's lied, that she's misled the committee, that misfeasance in public office, that he's going to launch a private prosecution against her.
Not me personally, my client, remember.
If all of that was so, and please, can I just make this submission without interruption?
But it's not me, is it?
Okay.
Mr. Rankin.
Mr. Rankin?
If that was so, if his argument is, well, I've got CCTV to gainsay everything in July, everything post the 3rd of July, why isn't that the case pre-July, which was your...
That was my
Because it was
question.
on 16th, we got them before, the day before.
Yeah.
So I couldn't prepare in that time.
I think the point being is that we still had the CAD references within a month.
We didn't have the
So-
all the CAD.
So we didn't have all of, you had access because that is what you brought up in the last meeting. You had access to
The day
CAD
before, the day before.
the day before, yes. But at the end of the meeting, sorry, we had CAD references up until the 3rd of July. So there were, okay, maybe not the 16th of June, but the 22nd of June and the 3rd of July, there were CAD references for
But no detail. No detail.
but
of what was being
I
alleged.
mean,
And remember, Mr. Chairman, I make this point. You can be against me if you like. I mean, I'm here just trying to argue a point that for my client.
Yep.
And remember, when I say I'm arguing for my client, it's not me. It's not Mr. Dad's is doing it, and he's doing it. It's not. Mr. Rankin does this often. I make it clear I'm acting for my client. So, with respect, it's my client raising these points, and I articulate them on their behalf. The issue regarding the 16th July, we didn't know, and we asked for an adjournment and we got an adjournment, but we clearly didn't know, and it was made at that time that there was going to be a submission by the police that even though it was no crime, that doesn't mean it didn't happen. That's what the police said on that day, on the 17th. So I think that's a change of position. And we say they have now served evidence in July that actually does assist us. It helps us greatly. We do not want you to exclude it. We need that information. That helps our case. It should be disclosed to us because it assists our case, and we don't want you excluding it. It's absolutely imperative that that information remains, and we have the right time to prepare and respond. If you exclude that, I can tell you, so we're clear, if you exclude it, we will take no part in this hearing because it would be deemed unfair. Because we want that information included, it assists our case, and we should have time to prepare for it.
you have one final question, and then I think I'll take the committee to adjourn to the decision. On the additional CADs that were added, so we are talking of sorry.
I got it.
I've got a few different of these. So that's not.
Have you got the grid that I provided?
I've got the grid that I've got the additional papers with your printed out.
It's from the 5th of July, the new stuff.
Page. Sorry, I'm looking for the most up to date. So
Included in, was it 2B from?
So that's all of, 2B. So
Yeah.
that's all of the raw CAD data that was submitted last Thursday, which is additional papers 2. Am I right, Naz?
Yes.
So that's the raw data, and that's including that's including the letter from PC Denham on page 1, not page 145, because that explains all of the
Oh
old
yeah,
ones.
the circle.
On page 155. So you have, besides the CCTV, specific examples of the CAD being incorrect.
Yeah, and we want to go through it all, because remember, my client and I have only discussed it briefly on Friday, and we had a meeting today. And also the Traveller Gypsy League, as also, I met with them today, and we have discussed the point about hate crime, and they're saying, actually, people making malicious calls against a protected characteristics of group, that's a hate crime as well. So
that's also submitted within the evidence from the police on the term traveller. That was.
So we're talking about the malicious calls.
The malicious calls.
So that's why we want to go through it all in very detail and produce the CCTV and the argument and potentially a statement from the Traveller Gypsy League that shows that we are targeted.
Cool. What we're going to do is we're going to adjourn briefly to make a decision on the full adjournment. Thank you.
So you've still in your pen.
I love it.
Police officer, they want.
Council property and the council. I've acquired a pen. Thank you. Before I read this decision, can I pass over to the legal officer? Firstly, can we hear again online? Councillor Small, can you hear us?
Yeah, I'm here. I can hear you.
Thank you. Perfect. I defer to the legal officer for summary of the advice given.
Thank you, Chair. As you know, this will be a summary and not detailed in my advice. You heard me read out earlier that Regulation 12 of the Hearings Regulations gives you the power to adjourn where you consider it to be necessary for consideration of any representations or notice made by a party. I've also drawn your attention to, although that's not the way the discussion was had in the meeting, I drew your attention to Rule 28 of the Local Procedure Rules. This is the rule which deals with a case where a party wishes to rely on documentary evidence but has not fully complied with the requirement in Rule 25 to present it 10 working days before a hearing. I drew your attention to the various provisions within that, which I won't read out. Those are available on the council's website. In those situations, the subcommittee has to make a decision whether to admit evidence far less than 10 working days in advance, by reference to reasons for the late production, how far any other party may be prejudiced by the late production of the documentary evidence, and the extent of the prejudice to the party seeking to rely upon the evidence if its submission is refused, and finally, whether it would be desirable in the public interest to adjourn the hearing for any period of time to allow any other party a reasonable opportunity to consider said documentary evidence. So I drew your attention to those as containing representative factors for you to consider.
So, Mr. Greenberg, I will now read out the decision. So the subcommittee carefully considered the decision. Our decision is to refuse the application to adjourn. The reasons being, we do permit Mr. Dadds and the police to make reference to the CADs that were submitted, the CADs post 3rd of July, which were submitted last week. We do note that the client may suffer prejudice with the inability to file rebuttal. Against this, we set the public interest in a resolution to this case. The decision we have taken is the correct balance to continue today, and we will take into account the limited opportunity for rebuttal evidence by the licence holder when making the final assessment. Wait to the final evidence. So our final decision will be weighted based on the evidence will be weighted within our final decision. So with that, I will move on to.
So I don't disrupt the meeting. I'm going to withdraw, as I indicated before. You have some documents that we've served. We'll take that into account. We are withdrawing on the basis that it's not a fair hearing. There's no disrespect meant to you, but that's our view, and we accept that you have a view. So on that basis, we're withdrawing.
Okay.
So I'll just pack my stuff without making too much fuss.
That's fine. In terms of procedure, can I just have a quick word with the clerk?
Yes.
Oh, okay. Right, the procedure for this meeting has been emailed to all participants by the clerk. For purposes of any member of the public watching, we will first hear from the licensing officer. The subcommittee and the premises licence will have the opportunity to ask questions. In this case, the premises licence accused that. The supporters to the review application present their representations. The subcommittee and will have the opportunity to ask questions. Finally, in this case, the premise license holder has refused their opportunity to representation to the subcommittee. All parties will then have the opportunity to sum up, and then the meeting will conclude and allow the subcommittee to deliberate and reach a decision. The decision will then be provided in writing within 5 working days of the meeting. If you wish to speak, please raise your hand and direct all communications via the chair. We'll take all papers as read unless there is anything you wish to draw our attention to. Be allowed allocated 5 minutes to speak. When speaking, please be succinct and do not exceed the allocated time unless you request an extension of time, which is at the discretion of the chair. Please do not share addresses of speakers. In the event there be several speakers for each party, please avoid repetition and perhaps consider having a spokesperson to address all the concerns. So, moving on to item 6, application for the review of premises at Hornsey Arms Limited, 26 High Street, London, N8. Miss Barrett, can you please introduce your report?
Thank you.
26 Hornsey High Street, N8. The application was submitted by the Noise Team Responsible Authority and relates primarily to the objective of the prevention of primary disorder prevention. Has also been cited in the application. The application can be found at Appendix 1 to the application contends that the operation of the premises has led to public nuisance from large numbers of patrons congregating outside on the pavement, also fights taking place.
Chair, I'm sorry to interrupt. I don't know if you can hear me, Chair. It's very difficult to hear Miss Barrett. If it's possible to get the microphone closer to Miss Barrett, please.
Miss Barrett, do you want to sit here? Sorry.
Sorry to interrupt.
It's quite a crowded room, Councillor Small. Can you hear her any, Stella, please?
The premises licence holder is Hornsey Arms Limited.
1 sec. Can you hear her any better, Councillor Small?
Yes.
Yes, thank you.
Designated premises supervisor is Miss Gemma Crucifix. At section 1.3, Chair, you have the timings that are currently shown on the licence, with the premises being able to operate Monday to Sunday until 3 to 3:30 a.m. The copy of the licence is shown at Appendix 2. There are representations from the Met Police, all councillors and residents. These representations set out several complaints received from residents and a number of attendance by the police to the premises to deal with ASB and other issues reported. And representations are attached to appendix. In terms of the consideration by the licensing subcommittee, the committee may, after hearing all parties, decide to modify the conditions of the licence, exclude the licensed activities from the scope of the licence, remove the designated council supervisor, or suspend the licence for the period not exceeding 3 months, or to revoke the licence. We ask that full decisions are given on whatever the term. In terms of background, the premises initially came into the licensing act in November 2005 under grandfather rights. Premises were taken over by James on 29th of October 2021 under the name of Hornsey Tavern Limited. Mr. Cairns was the director. The premises was subsequently reviewed by a resident on the 14th of March 2022 due to noise and other issues arising from the venue in the evening into the early hours of the morning. At that particular review, the licensing subcommittee determined to add conditions to the licence. Premises licence was then transferred in March 2024 to Hornsey Arms Limited. Mr. Cairns is also the director for that company, and you have a copy of the licence in appendix 3. Section 3 shall set out there the previous parts of the policy and the section 182 guidance for with, and a reminder that other considerations of section 17 of the Crime and Disorder Act 1998, as well as the Human Rights Act. Which I'm aware that you are fully aware that there are additional documentations there. And just to draw to your attention, obviously Mr. Downs is not here now representing Mr. Kearns, what you do have is that, the documents that he's actually submitted, we actually did ask for that to be taken into consideration.
Thank you. Any questions from members to Ms. Barrett? No questions, thank you. We will now hear from the review applicant, Mr. Bellringer. Can you please make your representation?
Yeah, so the Hornsey Arms or Tavern, we've had a history of complaints dating back to the 12th of September 2022. So since the review was heard, or since it was initiated by myself, we had 82 reports of mixture of music and people noise. Some of these reports are outside of our service hours, which is 6 p.m. to 2 a.m, so we can't always be there to witness the noise that residents report. On the 13th of January 2024, at 22:57, officers attended a local resident's property to hear excessively loud music. They issued a noise abatement notice for that instance. On the 29th of March 2024 at midnight 01, we received another report from a local resident that loud music was playing. Officers attended and observed loud music within the bedroom, and a fixed penalty note and was subsequently paid by the DPS or by the designated people in that premise. On Saturday the 15th February 2025 at midnight 05, officers attended and could hear a specific song within the resident's property and deemed that to be a noise nuisance. That was myself. And we issued a further fixed penalty notice that still is unpaid. Subsequently, they initiated an appeal for the abatement notice, and which we had to withdraw due to the company's change in name. So we issued the abatement notice to Hornsey Arms, or to Hornsey Tavern, and then when that was issued, the name changed to Hornsey Arms, which then deemed the abatement notice to, we had to basically withdraw that. So we've tried to take enforcement action, and unfortunately we haven't been hugely successful. I have also met with James Kearns on 3 occasions to discuss. One was in 29th of January 2024, and the landlord of the property to discuss the abatement notice and what issues and how to mitigate the noise. We also discussed to not allow third parties like DJs to be able to bring their own noise equipment, and all the music that was to be played in there to be routed through the noise limiter that they had on site. I met again on Thursday the 29th of June 2023. I met with Mr. Kearns and his licensing consultant, and I explained the recent reports of music and what action we would take if we witnessed further instances. Thursday the 17th of November was my first meeting with Mr. Kearns. I offered advice and explained the reports that we were receiving from local residents and how we can mitigate that, and again from previous meetings or subsequent meetings I had with him. Some of the reports around the smoking area at the front of the public house, making noise and having drinks outside when the pub shuts, people loitering outside. And a review was called by a resident in April 2022. Also, when I put the review in, working with the licensing police, I am in support of, I asked for a reduction of hours and some further conditions, but in light of what the police have submitted, I am sort of supporting that if we go for anything stronger, a revocation, I'm also supporting of that matter. At the time, the evidence is what I had to be able to sort of pull upon of the issues that we've been given as a noise service, and I didn't know about the fights and stuff that happened later. So I'm in support of any further action taken.
Thank you. So the end. Questions from members. Can I have a stab at the first one? Issues since the beginning of the year. Are we still getting noise and nuisance complaints?
I had a brief look, and yes, we've received between 4 and 5.
Between now and January and now?
No, since I put in the documentation.
Which
review, which was
June. Okay, 4 or 5.
And it seems to be the last couple have been about it's not so much music, it's more about machinery noise, about people loitering, and about a fan noise.
Okay. And in terms of the timings of complaints, I note in the original report, which now seemed quite long ago,
Yeah.
that you know, there's not really any. There's a lot of out of service reports. So we're sort of talking Monday, Tuesday, Wednesday evenings. I think I did make a note of them, what days they were, and also, you know, one or two that were, you know, 10, 12, 3 o'clock during the day. Is that an accurate representation of the spread? Are they focused mainly at night, but with a few sprinkled during the day and out of hours, or
Yeah, so
the distribution? I think.
well, yeah, obviously that's everything that's been, that document there is everything that was logged through the noise service and was logged on our system. That is how I put the chronology together. Obviously, residents know when the out of hours service is running, so they obviously do direct more complaints in that time. But like you can see that we still get complaints outside of those service hours.
Okay, thank you. Councillors?
Can I just ask, I think it was mentioned that some in your, when people did read, were they any indications that their attempt at trying to I don't know, malign anyone?
Not that I'm aware of, but for us to be able to take enforcement action, we need to be there and witness it. So officers issued an abatement notice that they deemed that to be excessively loud, and we subsequently issued further 2 fixed penalty notices. Officers were there, they heard how loud it was. In my opinion, we've been there, we've assessed it, we did that to be excessive.
And I was just wondering, in your, because you've obviously met him, did you think that he was taking any notice of the license holder? Did you feel that he took notice of what you were saying and took on board the kind of improvements you were asking for, actions you were asking for?
He didn't, because obviously I've met him multiple times and we've still gone through an enforcement process. We've issued a noise abatement notice, we've issued fixed penalty notices. So the advice I gave him wasn't followed. It was, and we've carried on still receiving complaints from local residents being disturbed by this premise.
The unpaid fixed penalty notice, how long has that been outstanding?
Since it was issued.
Which were, sorry, that's the second one.
But that's the one that's had to be withdrawn because they changed the company name.
That's negated its validity.
Yeah.
Yeah. Okay. So it can't be reissued because that company's dissolved.
Yeah.
Cool. Councillor Costa.
Yes, a couple of questions, if I may, Chair. How does this venue compare with sort of other comparable pubs in the borough, with the amount of complaints you've seen and also with the additional evidence, obviously the police have supplied to the hearing? How does this compare?
Public houses?
Yes.
I would say it's probably the worst one, most complaints we receive.
Okay, thank you.
And that's across the entire borough.
Yeah.
And I think you've addressed my next question through my colleague, but do you think the premises, the licence holder and the DPS actually took this concern serious that you raised with them?
I believe that they did do some soundproofing. When I attended in 15th of February, I was the officer that attended then. At midnight, I spoke to the Kearns, who tried to show me pictures of the soundproofing that they'd done. And I did say to send an email over to me with that information. But I didn't receive anything. So I think they've tried. I think the ability to sort of manage people, manage what's going on inside the pub.
So actually, you very nicely led into my next question, because obviously, so they've shown you some attempted evidence of soundproofing, but in fact, isn't it the case that most of the problems, noise and disturbance, is coming from outside the pub as well as inside the pub?
Yeah, so when I did attend on that day, the front door was wide open and there was karaoke with people obviously speaking karaoke, which is right inside on the right hand side of the pub. So the door was wide open, there was multiple people out the front. Yeah, things like, you know, soundproofing was, I believe, was the back end. But nothing towards the front. If you have a door wide open, it's going to affect residents.
Can I just come in very quick? When you say there were people outside of the front, rough head count?
7.
7. Okay, cool. So within the license
Yeah.
of 10 outside. Okay.
And actually, on that note, you've also teed me up very nicely on the next piece as well. So obviously, there were additional conditions put in after the review of the 22nd of 2022. Apologies. When you were at the premises during sort of evening or late hours, did you witness or see the two mandatory SIA?
I've only ever seen one.
And was the reason ever given to you for not having two?
No.
When was the last time you visited?
In February.
In February, and there was
One. There was. I spoke to the female security officer and said, "Can I speak to James or the DPS?" And James came out. There was only one.
Yeah.
Sat at the front. It seems to be. It's the same female SIA. Seems to be every time I've gone there, she's always the same person.
Okay.
One last question.
Yeah,
so, in your professional opinion, do you consider the current management to be fit and proper people to hold a license, given the lack of improvement over an extended period, despite offering certain engagement?
No, I don't. I don't feel like they're capable at the moment or up.
Thank you. No question.
Thank you, Craig. Boring. Shika, sorry.
Yeah.
Simon, yep, sorry. Should come back to you in case there's anything that you come back. Right, in which case we will now hear from, sorry, everything's moved all over the place. Yep, we will now hear from those who have submitted representations. So I think the only one online, we will start with Councillor Small.
Thank you, Chair. Thank you, members of the committee, for allowing me to speak this evening on behalf of our residents in Hornsey who are deeply concerned about the situation. I'm going to do my best not to repeat any of the facts that are already set out in the detailed reports of opposition submitted by the police, the noise team, the ASB team, residents and us as councillors. But instead, I want to try to set out why I believe that the licence holder has shown themselves unfit to hold a licence, and why I strongly believe that revocation and not just curtailment of the licence is the most necessary course of action. As is evidenced in the reports, the licence holder at North 8 or Hornsey Tavern has repeatedly and egregiously failed to uphold the most basic requirements set out in the Licensing Act 2003. We're not dealing with a few isolated incidents or minor oversights, but we are facing a sustained pattern of serious failings that have caused repeated and serious distress, fear and concern to Hornsey residents, but B, I believe undermine all 4 licensing objectives. So firstly, if I take them each in turn, the prevention of crime and disorder. Since March 2024, there have been over 39 police call-outs to the premises on over 25 separate dates. I'm not going to get into the veracity of each claim and the disputes between the police and the committee. You yourselves will be responsible for deciding what is crime, what is disorder, and the truth of each. Between February and April 2025, when this review was instigated, there were 24 calls to the venue in just 2 months, nearly all related to violence. Since this review began, there have been over 21 calls to the police, with 13 relating to violence. And I want to stress to the committee that by the time the police are called, we are at the point of maximum escalation, and the regular call times after midnight usually represent hours beforehand of increasingly rowdy and disruptive behaviour, which has been set out extensively by residents in their submissions to us as councillors. I also want to point out that we have 2 other pubs within 500 metres on Hornsey High Street, and even if you do remove some of the claims counted, we're looking at the police evidence, it's not even remotely comparable, the levels of violence, crime and disorder that we have seen at North 8. And most importantly for the committee tonight, these incidents are not one-off disturbances, but represent a sustained pattern of disorder directly linked to the premises and its mismanagement. The licence holder has repeatedly failed to control the conduct of patrons, both inside and outside the premises. And despite police intervention and action taken previously by the committee, the licence holder has demonstrated very little commitment, if no commitment, to barring difficult customers or barring those that commit crimes. On one recent occasion, when the police intervened to address a violent fight, the licence holder explicitly told officers that he was happy for the individuals to remain, and there is documented evidence that individuals involved in violent incidents were allowed to return to the premises at later dates without any attempts at barring. Conditions imposed previously by the committee required 2 door supervisors on duty, and the licence holder admitted that despite extensive issues with crime and disorder, he only had 1, confessing that he explicitly prioritised profit over safety and legal obligations. Second, public safety. So if you visit the North 8 pub, there is currently a glistening of glass around the surrounding streets from months of fighting, smashing bottles, glasses and windows, vomit and urine outside the doors, large drunken crowds spilling onto the busy high street, creating serious hazards to both residents and road users. As the councillor regularly walking past, I can assure you these problems are present even in the daylight and at times when children are walking home from nearby schools. Video footage submitted by residents shows people running along the street to try and escape men fighting in broad daylight. Other evidence includes a female patron served alcohol to the point of vomiting and then attempting to drive home. And while I accept the licence holder is evidently not responsible for the attempt to drive drunk, they are very much responsible for intoxicating the client to such a state that she and others have required hospitalisation. Thirdly, prevention of public nuisance. Noise complaints, as you've heard, stretch back as far as June 2023. Residents have repeatedly told us they are unable to sleep or woken up 3 or 4 times a week. Even after the noise abatement notice and the fixed penalty notice, they're still woken up multiple times. One resident forced to raise the issue with their workplace HR department because they were so exhausted and repeatedly turning up to work distraught. Another resident has described changing their daily routines, avoiding their own high street and living in constant anxiety about returning home after dark. And I should add that most residents have accepted that living on top of a pub will come with disturbances. What they don't accept and shouldn't have to is that these disturbances continue far into the early hours and in spite of licence holders' accepted legal responsibilities. Fourthly, the protection of children from harm. Most importantly, I think children have been served alcohol on the premises, with one confirmed case of a 16-year-old at nearly 3 a.m. and a further concern from police whose body-worn camera footage indicates very young persons drunk in the pub in the early hours. The licence holder's own policy instructs no children be allowed in the pub.
Councillor Small, you've reached your time. I appreciate your submission. I don't think we have any representation online from speaking, so I'll move on to the police representation.
I may take slightly longer than 5 minutes, but not longer than 10.
So the chair's discretion.
It is the chair's discretion.
I know you've read the papers, but there are.
No, we do all the questions that we ask questions to the council and all the supporters.
Promise not to go beyond. I really promise.
I do appreciate that, Mr. Rankin. I think that in light of, we will be asking questions of you and of Councillor Small. I think in light that the fact that the applicant holder, who I know has chosen to refuse response, I think that in light, if we can keep it to 5 minutes, and then we will have, I'm sure, we all have substantial questions on the substantial papers before us.
Thank you.
So 5 minutes, please, Mr. Rankin.
All right. You remember asking me the question last time on the 17th, what was the police position? Why weren't we going for revocation? We've had an opportunity to change our position now. We've looked at what's happened since the 17th of July. We've changed our position. We would like revocation because it's not hyperbole or exaggeration to say these premises are lawless. They are out of control. And just to give you an example of that, since the adjournment on the 17th of July, what normally happens is that when papers are served by responsible authorities, there's a change in behaviour. That's what normally happens. Quite the reverse has happened. These premises have become worse since the service of the papers. So in the lead up into the hearing on the 17th of July, 3 months, there were 21 calls to premises for 13 separate dates. 8 of those were for violence. And then since the adjournment, and this is the telling figure, between the 4th of July and the 30th of July, in other words, just a little over 3 weeks, there have been 16 calls to the premises for 9 separate dates. And 8 of those 9 dates were for instances of violent assault. And just to give you examples of complaining, it is a variety of people. 11 different people called the police. It's not a question of malicious calls, because those 11 people were made up of 6 residents from Verisure, who were the alarm company, from the security at the premises themselves, and from bar staff. But those are the people that have called. And you may ask yourself this question, well, how's that malicious if the premises themselves are calling for help? And yes, Mr. Dand was absolutely right that I would say this, that because there have been 77 calls in the last year to these premises, from 48 dates where the police have attended on 45 victims. 36 of those have been for instances of violence. It may well be that at the time we turn up, the thing is over. It may also be, and that's reflected in the papers, that when 2 police officers turn up to an incident where 70 to 80 people are involved in a melee, and you don't start arresting people for a fray. What you do is you start clearing the path. That's the sensible thing to do. So it's a non-point for Mr. Dand to say, oh, well, you see, there was no crime because nobody was arrested. The reason nobody was arrested was because they were doing good police work. But the point is they shouldn't have to do this. There is a league table that the police keep. They're number 8 in the league table. Remember also this league table includes 3 stadium venues and Alexandra Palace, huge capacities. Serious allegations were made. We take great exception to any suggestion that my officers have lied, misled this committee, have committed misfeasance in public office. They have never sought to say in these lists of CADs and CRISs, they've never sought to say on each and every occasion offence was committed. They've always sought to say this: we have been called to the premises in order to deal with instances of violence. We want to put an end to this. That's my submission.
You didn't need the 5 minutes, Mr. Rankin. You didn't even need the 5 minutes. That was 3 minutes 47. I think that's all of the speakers who were listed. So we'll move to questions. I would like to ask the first question as a clarification question. The Verisure alarm system, is this the alarm system that is triggered by the bar?
Yes.
Okay, so all of the Verisure calls have been logged by the bar, but the bar staff may also be making 999 or 111 calls.
Panic button.
So there's a panic button, but they could also be making direct calls.
What is interesting on the Verisure system is that you can tell how many times it was pushed. And in one instance, it was pushed 10 times. So
Yeah.
clearly there's a sense of urgency.
I can't
In
remember.
another instance, 7 times, another instance, 3 times.
So I think that there was a I can't remember which instance that was, but there was one transcript which said, I've tried pressing the button 15 times, not sure if it's working. Is that's correct. So I want to turn to the CAD that was submitted. It's page 258. It's the 3rd of July. And please excuse me, I've never gone through any of these in details, but from what I can infer, the call is I have been grabbed by customers. They are refusing to leave and have assaulted me as I've been trying to get them out. There are approximately 30 to 60 people here, all refusing to leave. The security are contacting you now. We have 2 security on scene, but cannot manage the situation.
Yes.
So,
Thank you very much.
yeah, sorry. So that is one direct transcript. What I want to know is how common is that sort of language across all of the call outs, i.e. being there's a big situation going on in the bar. We can't manage it, we need the police.
Yeah, I would say there's a substantial amount from bar staff. There's a couple from security and from the alarm system.
Yeah.
Daily, there's a big group here. It's got out of hand.
Okay. And the sort of impression, so I can't, the resolution of this one,
There was a common assault crime report.
common assault, everyone is pulling away from the pub, so sort of everyone has dispersed from that. Was that one, anyone arrested, charged?
I think it's been.
Sorry, I can get the, I didn't, this was me determining it after. So 3rd of July in your, there's 3 instances related to the same incident. Police arrived on scene, request more unit, and the dog unit, 2 dog units aside, appeared to calm down and reported a common assault. Common assault, a staff member had their arm grabbed by a patron after being told to leave. The victim stated the travelling community were attending the pub for a wake and became extremely drunk and refusing to leave. The CAD stated security on scene could not manage the situation. So
Yeah, so that was the victim did not wish to provide a statement. They were unwilling to prosecute.
Okay.
And no suspect identified.
right. So what I'm trying to determine is whether when the bar staff are either making calls or using the Verisure system, is it because they have lost control of the pub and therefore are relying on the police to come and temper the situation, manage the situation? Is that correct?
Yes.
Question related to that point.
Yeah, of course.
So on that, in your view, do other pubs utilize you as the same service, basically breaking up fights they can't control, or do you feel that the venue is the premises is using you because they are unable to control their own patrons?
Just from my own knowledge of the borough, I am not entirely sure, but I don't think there's any pubs calling the police to manage situations this frequently.
Yeah, as you basically Mark Craig, central licensing, the way that the system works is that if there are premises that are causing a problem, the licensing officer will go and speak to them and try and put in place measures to prevent those problems from happening. People with this stepped approach. If you've got a premises that's continually calling the police and dogs being incredibly rare, dogs are very difficult to get hold of, but they're used for the most serious public order situations. So if you've got a dog units, that's incredibly serious risk that police officers most of the time there. We take a very dim view of our resources being used to act as supplementary security for licensed premises. And the vast majority of cases in London, we will make absolutely sure that if we think that's the case, that the licensing team together there and work with them and try and solve the problem of stores. In this case, with the sheer number of calls coming through, with the panic alarm being pressed from a premises that's under review, is shocking.
Yep. So on that point, so in the original submission by the police towards, so in your original statement, you had an online Teams meeting with Mr. Dadds, and there was a discussion on an action plan for officers to consider. However, this review intervened with that that process. So you stated that you were submitting evidence for this review before the action plan was agreed. However, the action plan by Mr. Dadds is outlined as temporarily reducing operating hours to last orders at 2300 hours and premises empty by 1 AM, temporarily restricting to entry to 2300 hours except for the readmittance of smokers and applying an over 21s policy at the weekends. Have you, sorry? Yep, I was going to say, have you seen any evidence of this in the past? Well, since you received this action plan.
Just through the sheer number of calls.
Am I right in assuming that this action plan was offered after you told Mr. Dance that you were going to support the LA in their?
So if I read the full, Mr. Dad stated he would email police, licensing team an action plan for officers to consider. An email regarding this was not received until after police, Mr. Dad's supporting representations to the review would be submitted by police licensing team. The exchange of emails took place on the 1st of May 2025. Following a courtesy notification regarding submitting representations, Mr. Dad's emailed back some suggestions as below. So, yes. So my question is, has this ever been, to your knowledge, implemented?
To my knowledge, no.
Okay.
The original representation speaks about early engagement. And the first, you're quite right, there was the Teams meeting, and then there was an actual site visit on the 14th of March 2025, when a number of breaches of conditions were seen. They only had one SIA, there was supposed to be two, no refusals book. There was an issue with the CCTV, which has since been rectified. And all sorts of promises were made at that meeting that they would be using Licensing Connect, which is Mr. Dad's software system, and that they would be implementing 2SIA, that they'd be having wave training and taking positive steps. And then, remember, that was the 14th of March. Only 3 days later, there were a series of assaults that allegedly took place. One on the 17th of March, and then 9 hours after that one on the 18th of March. The police report of fight, where there were 2SIA, but they couldn't control the people that were there.
Can I ask? I mean, when you've met with them, and I think I can't remember the exact spot, but I remember in one of the reports, I recall it was said that even Mr. Cairns felt he wasn't managing, and that he felt he couldn't manage, and was thinking of how you get a weekend closure because he wasn't managing. So I just wondered about how that, if you feel you're the license holder and you feel you're not managing, I just wondered how that feels for everybody else, because there's no security, and knowing that someone else is, the person who's responsible for the whole thing is running it well. So I wondered about that. And also, I think, he, again, he was in one instance, I think you found him that he'd been drinking himself, and that was noted in the report. So that, again, it sounded as if he couldn't possibly have managed what was going on there, and didn't have the kind of ability to do that. I just wondered about that, kind of thinking about the fact that I was wondering whether you feel he was competent enough to manage the pub with the kind of issues that were taking place there.
The picture's been created by these Christian Cads of somebody that has lost control of his public house. So, for example, there was one instance where members of the travelling community had leapt over the bar and had taken items from the other side of the bar. And quite a lot of these Christian Cads are resolved by Mr. Cairns saying, well, it's all sorted, they've given me £300 for the window. It's all sorted because they've apologised and they've given the entertainer who was thrown against the wall, they've given him £300. It's Mr. Cairns firefighting a set of premises and not doing it in a very competent way.
So then, can I ask, why haven't you issued a closure notice now? Because there's been so much. I go through the reports and I feel there's a lot that's taken place, and it feels like it's not just one opportunity to close it. It feels to me there could have been a number of opportunities to close, and no closure notice was issued.
Well, that would be right. Certainly, we gave careful consideration to the issue of a closure notice when we began engagement, face-to-face engagement on the 14th of March. And we looked at the question of a closure notice at that stage. And what was promised was that there would be an increase in CCTV coverage and that there would be coverage throughout the whole of the premises. There wasn't before. And that they would be engaging Licensing Connect and doing wave training and the rest of it. And so as a result of those positive proposals by Mr. Cairns, the police rode back from applying for a closure order. But what was clear was that there was minimal effort applied to making sure that the premises were run properly. And the question of a closure order was considered again, but then events overtook us because Mr. Bellringer was ahead of the curve and applied for his review. But if he hadn't done that, the position is that we certainly would have done that. Is that right?
With the various call-outs, obviously Mr. Dad's disputes that they are all criminal or no one was charged. What extent do they fall under ASB, which might not be as accurate? That is the noise and nuisance if you're dispersing a crowd of 30, 60 people from a pub at a late hour, for example. How much do they fall under that category? Maybe not criminal, but definitely fall under antisocial behaviour.
They all fall under antisocial behaviour. Many of them fall under violent disorder.
Right.
But all of them count as antisocial behaviour. When you're clearing a pub with people that are scrapping inside and outside, when people are being punched across bonnets of cars, it's a fine line between whether that's antisocial or whether that's violent.
And I guess, do you find when you attend the premises that, as I asked Mr. Bellringer, the conditions of the licence are 10 patrons maximum outside? Is it bound
in the breach rather than the observance? More observed in the breach rather than the observance of the condition.
Right. Okay. So you see it more often that there are more than 10 patrons outside the bar at one time. Yes, did you have a question?
I've got quite a few, so
okay, cool.
Continue your questions and then I'll go into my.
No, I'm sure I'll split into some of yours a bit if you want.
Okay.
Take over.
So on the topic of the CADs, would you agree that while not every CAD resulted in a recorded crime, the sheer volume of police attendance goes above and beyond what's expected for a normal venue?
What do you say?
Yeah.
Absolutely. And what's been, we had this disagreement, not with yourselves last time, but with Mr. Dad's. What's the impact on police resourcing in Haringey, in the borough and across North London?
If you've got an establishment that's requiring a team of officers that are on shift to go to numerous times at the same night, that is huge. Never alone one. If you've got a pub of 50, 60 people, you're sending a unit, you need multiple units to attend this. And often other units have been drawn in across London, PSG units, dog units. It's a big approach. The sergeants and governors have actually gone and given statements themselves regarding this premises. So
The problem with London from a Met-wide point of view is that every police officer, every 2 people, because most police officers are vehicles are double crewed at night for safety reasons, is that every police officer or vehicle that's dealing with that pub is not dealing with a sexual assault, not dealing with a robbery, not dealing with a burglary. They're not dealing with that because they're dealing with the mismanagement of the pub. And this happens again and again and again and again. It's simply untenable.
And with regards to that point, the high number of high risk CADs requiring, as you've mentioned, immediate officer and multiple officer deployment, do you believe that this reflects a serious risk to public safety? Of the incidents I started losing count, but there's a 60+ incidents. How many of those were multi-officer call-outs? Approximately.
I couldn't give you an exact number, but yeah, from experience, you know, you call multiple units to these sort of things.
Yeah.
And if you are a single, you're not going to go.
On the evidence provided, both the witness statements from officers in the 2 witness statements from Shannon and Louise Kearns, and on the body worn camera, have there been clear breaches of the licensing conditions?
Yeah, and just from talking to him, well, I mean, one of them, the 16-year-old that was when they're already intoxicated. Again, there was no CCTV, no refusals log, and like the refusals log's just fine enough, but yeah.
And
Have
those,
they-
SIA,
Have
yeah,
they sent it off to?
yeah, when we went to do a follow-up visit, they'd rectified that, they'd signed up to Licensing Connect,
Right.
which had it on.
Have you seen? Has an officer seen the refusal?
We've seen it, they've got it on their phones.
Okay, they've got it on an app, and does it have refusals in it?
I've not seen any refusals, but yeah,
So for clarity, a refusal, anytime a minor would try
or
to
if you're
purchase,
too intoxicated.
too intoxicated, a minor would try and purchase, and the bar staff refused.
Yeah.
Then it gets logged there.
Yeah,
Okay, but no one has seen.
I've not seen any entries. So I couldn't-
But have you seen? Have you had access? I mean, I'm not. Sorry. What I'm saying is, have you actively seen no entries, or have you just not
when we
been able
did the
to access?
follow-up visit,
Yeah.
hadn't seen any at that point. They just showed me that they had it, but
Right,
I haven't
okay.
since checked.
Okay, I think we can ignore that.
Can I ask on the?
Yeah, no, of course,
I really want, I just on that same thing, I was just wondering whether you did ID checks with them at all. Did you check how old they were? Because it seems to be, they're there on the body worn cameras and everything, but nobody is checking to see how old they were. And that worried me that, you know, people in authority are not checking. And were there any safeguarding concerns reported by you guys? I mean, you know, you must be in a position to report these kind of incidents, especially if you recognise them or not recognise them. I don't know. It's difficult. It feels like people know that younger people who shouldn't be there are there and are drinking, and yet nothing has been done.
Obviously, from a licensing perspective, I can only answer the officers that have been on the CAD, because we're not there ourselves. But I don't believe any checks were carried out by the officers on the scene, but that wouldn't be standard while you're attending for the ASB or the fight to start going around IDing people.
Okay.
Possibly they look younger, and also, you know, what looks young to me may not.
So I want to stay on the underage drinking point, and in reference to I think it was the event on the 18th of January, CAD 825, where the young gentleman was served 2 half pints at 2:30 in the morning, and specifically relates to the witness statements, Mike Golf 11, so MG 11, where Shannon Kearns witnessed, and I'll quote, "To keep him calm, Louise has said to the bar staff to give him 2 half pints," end quote. And that was a 16-year-old young gentleman at 2:30 in the morning. Do you think it's appropriate behaviour?
Can I just clarify? Was the 16? Was it verified that they were 16?
Yeah, because the criminal damage was committed, and the 16-year-old was the suspect.
Okay, so it was verified that they were 16. Thank you.
Yeah.
Okay. So, firstly, yes, it verified 16-year-old who then caused violent damage to the premises. In Shannon Kearns' statement, she said to Louise to serve him so that he would stay calm. Do you think that's appropriate behaviour of bar staff to serve a 16-year-old at 2:30 in the morning alcohol?
No,
And to keep him calm?
anytime. To keep anybody calm.
And did the licence holder did the licence holder explain how the 16-year-old was allowed on the premises past 2 AM? on a similar topic, in your report, you mentioned that on one occasion, Mr. Kearns drove off whilst police were left dealing with a violent incident. Annoyingly, I've lost the page reference for that. I believe that was in your original submission.
Yes.
Is it responsible of the licence holder to do that? And let me go back to my original references. Apologies. I will pass back for a moment because I've lost my page.
Oh, okay. Councillor Amend, do you want to?
I think just to go back on the issue of whether Mr. Kearns was struggling to manage the premises, I just wondered, would you agree that that because of that, there's a risk to public safety if the licence holder really minds us?
Yeah.
And do you believe the premises currently has the capacity to meet its licensing obligations?
Councillor Small. Are you still with us?
Still here.
Thank you. I appreciate that most of the questions have been directed at the police. And I would like to know, so in some of the evidence that was submitted, not by you, but by your residents, there is, and also in the video evidence that we've been provided as well, there's evidence of rowdy behaviour and aggressive behaviour on the surrounding streets during the day. Given that there are 3 major schools near there, with St Mary's, Greg City and Camp Spanbourne a little bit further away, are there instances that have been reported to you that violent behaviour has occurred during school leaving time, so 3-4 o'clock in the afternoon?
Yes, I will concede not regularly. It is not something that I've been regularly made aware of. I'm aware in most cases the violent behaviour is much later in the evening, but it is definitely the case that on occasion this has occurred during school leaving times.
Thank you. I think that's the only question that I have for you, unless
I've got one.
You've got, yeah, go for it.
Councillor Small, thank you very much. I just wanted to see, have you had similar complaints about any of the other pubs in Hornsey? And obviously, Hornsey's got quite a few other pubs. Have you had similar complaints about any of the others?
Not one, not even remotely comparable.
Thank you. And you mentioned in your submission that residents expect, living above a pub or near a pub, that there will be some disruption. But how would you rate's the wrong word? How would you assess the impact on your residents as a result of the disorder ASB from the pub?
I don't know how to choose a word that sort of stresses the sort of 10 out of 10, sort of the unbearable is the word used. I know of residents who have given up a tenancy 3 months early in order to leave. The level of distress, distraught is a word that comes up a lot. But also just extend that slightly, not just residents that live above the pub, residents in the area that will not even go close to the pub at night. And even during the day, people go to the post office next door and they raise, serious concerns. And again, I think I stressed this last time, but just to stress, one of the reasons I'm involved is because the number of people who are very concerned, but were too concerned about their own safety to put their name to paper. They just wouldn't cross that threshold because they were so concerned about violent reprisals on themselves should they put their name to paper.
Thank you, Councillor.
I've got a couple of questions for the police, if I may.
Yeah, I have one as well.
I'll let you go first then, you're the chair.
With regards. Yeah, go for it. Sorry, Kashika, go for it.
I was just wondering, I think I had kind of questions about local residents. I mean, and the complaints that you're getting, are you getting them all the time? Is that what happens? I mean, how do they get to you? Do they email them? Do they complain to you in person? Do they come to your surgery? How are those complaints being relayed and recorded?
Sure. So those that live closest began by emails and surgeries, and then we've sort of been in regular contact also with staff member at the school opposite have been in touch in person. Those that are sort of further away have tended to add it on to requests or complaints, you know, attached to other things and said, also, while I'm here, can I raise this? So usually those have been surgery in person. And then I've also been made aware of them through representations made to the local member of parliament, who has then passed on complaints made to them directly to us.
Can I just very quickly follow up on one point that he made? Go for it.
You referred to the impact it's having on people's lives, people leaving early in an area that's actually quite nice. So I was a little bit concerned and wondering. I mean, living in Northumberland Park, I often talk to lots of people. And I just wondered, have you ever tried to engage with the pub management?
No.
Or any of the councillors?
No. No, I have personally not tried to. I immediately, when we first got involved, it was in our response as councillors as getting the officers involved at the council. What are the ASB team doing? What are the noise team doing? And so on. And we were picking up really at the tail end where the review was then instigated. And from that point onwards, the review has sort of carried forward. I should just add that some of the, whether reports are still being made or so on, is also reflective of the fact that people have been waiting on their representation deadline. I think it was early May, and people have been waiting on that since then. So we've had a lot of correspondence since then. But since the review was instigated, all our correspondence has been with officers.
Thank you.
I just want to follow up on a point that you made, and then we'll go back to the police. You said you had a contact from the school across the road. Could you expand on what their concern was?
Yeah, so they're also a local resident,
Okay.
but so their concern was they had noted that late at night there was these disturbances. They were then going out earlier in the morning with other members of staff in order to clear their area of debris. I wouldn't be able to clarify any further than that. Part of the conversation, I can make some educated guesses, yeah, and then a second follow-up was with regards to this, the disturbances getting earlier and earlier impacting the school.
Okay. Yeah. She could do any more for Councillor Small? Any more for Councillor Small?
No.
No. One thing that I want to ask for clarity from the police. Obviously there is an issue. Sorry. So what you are saying is that there is an issue with the license holder and their management of the pub. Is there any concern, like these reports, is it the same clientele who are having the same reports made of them? And I guess legal officers, correct me if that's relevant. I think what I'm getting at is if we were minded to take your recommendation to revoke this license, which is the recommendation from all of you, that's not our decision. We will determine that at the end. If we were minded to do that, is there an issue with, say, repeated call outs and you're experiencing the same clientele who are causing the same problems? And if the license were to be revoked, would they move elsewhere and find another pub to haunt?
I'm afraid it's rather like doing battle with a hydra. You knock one head off and then another one grows somewhere else. And it may well be displacement of the problem. But what we are concerned with is how best to resolve this case.
Yep.
What's happening to the residents? What's the drain on the police? What do your officers say? What do we think the right decision is? Do we fiddle about with conditions, or do we take a robust approach?
Is there any path to control, in your opinion, and I guess Mr. Bellringer also, I know it's not actually questions to you, but actually it's not questions to you, so I can't ask you. Is there any path to control with the current license holder, a new license holder, with the, is there any path to green? Is my overall question.
Well, on the question of conditions, our view is that there is no condition or raft of conditions that is going to satisfy the police at this stage, that this can be resolved with cutting back the hours or imposing a last entry at an earlier time, SIA during the week rather than just Friday and Saturday. There is no such condition, because things have reached such a state that the only possible resolution is revocation.
Yep. As well is that if a new earner were to come in, they would merely inherit the bad customers and the bad behaviour that's now endemic and associated with the licensed premises. Certainly when I've seen the CCTV footage, the clientele appear to know each other, seems to be one large group, modern group. It's unlikely, based on the amount of probability of them may looking at it, that there's anyone else who isn't part of that group. And certainly anyone who's going in there would see the noise and the fighting and everything else wouldn't want to go to that. But and were a new owner to come along and take it over, they would merely be inheriting those customers and the problems would be transferred to them. We don't think that there is, as Mr. Rankin said, any possibility of conditions being imposed or hours changed that would solve the problem. All it would transfer it.
Thank you.
What sometimes happens in cases like this is that if you've got a really troublesome pub, license revoked, the premises go dark for say 6 months, problem goes away, and then some new operator comes in, because there's nothing wrong with having a good, well-run community pub for the residents. New operator comes in, has a complete refurbishment, and then reopens the premises, but this time to a different demographic.
Councillor DeCosta, you have some questions?
I do. It's about the points that Mr. Dad's raised about arguing that some of these or a number of these CADs were malicious, or some of the calls out were malicious, and they didn't result in crime. We've addressed part of that actually there's still a pattern of behaviour. You've had to expend resource. On the argument that some of the CADs and call outs are malicious and false. Using using a professional judgment, with the number of call outs where there has been something happening, as in there has been ASB, there has been violent disorder, compared to the number of call outs where police have come along and nothing has happened. Do you, in probability, do you feel there's more likelihood that these aren't malicious calls, that actually people are responding to concerns about actions going on at the premises?
Well, there are two answers to that question. The first is to say that in all of these hundreds of pages, there is one reference in one CAD to it being perhaps a malicious telephone call. And that was in relation to the 13th of July, page 60 in your old.
The old one. Show us the old papers.
Well, the second tranche of the old papers.
Page 60.
But there's additional papers one.
Yes, 13th of July.
No, that's the new paper. That's the new papers, Mr. Rankin, I think. I've got.
Yes, it is. I'm an idiot.
That's all right. 13th of July.
13th of July. If you look at page 60, at the bottom there.
Believed to be a malicious call from neighbours.
Yes. And we've chased that up. And the origin of that entry in the CAD is Mr. Cairns saying, we think it's a malicious call. But that's the only reference we can find to malicious call. So if Mr. Dad was right, then every single call to these premises would be from a resident or an anonymous person, if it was to be malicious. or likely an anonymous person. We've done an analysis. So here are the figures from May 24 to December. The calls to the police, 5 of them came from the premises themselves. 1 of them came from Verishaw, who's the 3 came from named residents. I'm afraid we're not prepared to reveal their identity for reasons already explained by Councillor Small, and 1 anonymous person. So no red flag there, nothing malicious, we would suggest, or indicates malicious there.
Sorry, can I just clarify? So that's a total of, I should have 10.
10.
10 calls between March and December.
Well, there were.
So this is as in the original,
Yeah, 2024.
2024.
Yeah.
Oh, 2024. March to
May to
May to December. Oh, okay. So those,
Okay.
those 10 calls. I mean, there's a sufficient, Mr. Rankin, there is a significant, we're looking at just those on page 14 of the additional papers, they also own the other one. That's 10 calls compared to what, 30 on
Yes.
post that. I mean, I guess my initial question is, why was the analysis done on 10?
Put it on all.
We've done it on all?
Yes.
Okay.
And
so-
I give you the figures on all.
Oh, yes.
Yeah, I think that would be more.
But far and away, the lion's share of the complaints to the police.
So on that 40, I guess, that 40, how many came from the bar?
So we'd have to
We-
total them up. So from January.
Yep.
4 came from the alarm company.
This
2
is from January to
January
December?
25.
Or was it, are you just?
Just month of January.
Okay,
Month of January.
okay,
Okay, so very sure. Was
4 came from the alarm company. 2 from the pub itself. No residents.
Okay.
And 1 anonymous telephone call. So the alarm shot came from the pub or the alarm company operated by the pub. In February.
Yep.
8 telephone calls came from Verishaw, the alarm company. 2 came from staff. 2 came from residents. And 1 came from your own council's CCTV system.
okay. I add a new category.
Yeah, new code into that one.
And then March. 2 came from staff.
Yep.
3 from identified residents. And 1 anonymous call.
None from Verishaw.
None from Verishaw.
None from Verishaw. Okay,
In April, 7 from staff. 2 from Verishaw. And 2 identified residents.
nothing from anyone else.
Nothing from anyone else.
Can I have the figures again? Sorry, apologies for the December to May previous. The first
December
set of
to
figures.
May was 5 from the bar, 1 from Verishaw, 3 from neighbours and 1 for anonymous,
3 neighbours, 1 anonymous. Okay.
and none from the council.
And none.
So April, 2 residents, 7 staff, and 2 Verishaw.
Yep.
May.
Yep.
5 from the pub.
Yep.
1 from Verishaw.
Yep.
3 from identifiable residents and 1 anonymous. I'm sorry, forgive me.
May 6 different calls in May, and 1 security from the pub itself, none from the alarm company.
Sorry, can you, so bar staff, how many?
1 security,
So,
1 call made from
Yeah,
security.
I'm gonna, Bar and
Okay.
SIA and
Okay.
the same.
And then
How many from Verishaw?
none from Verishaw,
None from Verishaw.
and then 6 different calls made.
Okay, 6 different and
Different
split up.
callers, but I
different
can't say
callers.
The residents or people in the park don't know.
Right. Okay.
So it's just people identifying that by name.
How did we have? Sorry. How did we?
Let me get them.
Chair,
I'm-
if I can say, so what we've done is we've looked at the cats.
Yeah.
And we've looked at the phone numbers to make sure there are no duplicates. So in May, for example, there were 7 calls in total.
Yep.
5 of them were from residents, 1 was from security, and 2 of the residents was the same phone. So 4 different callers.
Okay. Sorry, but sorry.
Councillor Buxton is very meticulous, I have to say.
So it's ruining my system. Bear in mind we're up to the end of these ones, so these the May, I guess, is the new ones. So May bar staff. Do we have a total for that we know are bar staff? No,
From security.
one. Sorry, security. I'm including that and staff off the bar. 2 from Verishaw. None from Verishaw.
So that's how it's adding up to 6, because there's 4 from residents, 1, 1, 4, 6. So there were 6 calls in total.
So
Okay, and 4.
Yeah.
4 from neighbours.
5, so there's 1, 2, 3, 4,
Sorry.
5, 6 calls from residents. 2 of them are the same. So, so 4 from residents, 2 are the same. So 5 in total.
None anonymous.
One from security.
Okay.
And then June, 6 residents identifiable.
Yeah.
1 from the pub. No Verishaw.
Yep.
And then finally,
And nothing anonymous or council.
nothing anonymous then.
July.
And then July, 11 calls. 6 of those were residents. How many were Verishaw? 1 from Verishaw. How many for bar staff and SIA?
Got 3.
3.
So that gets 10.
11 calls in total for that month.
So we're
Any
anonymous.
So, yes, I've got 5 declined the person's call.
All right.
What does that mean?
So they declined to give their name, anonymous calls.
Okay, so I have
Got 11 different calls as well.
What?
More calls, people
Cool.
called in all at once.
okay. Okay.
Does that make sense?
Yeah. So I mean, what I'm seeing here is that there is a trend that I mean the calls are coming from inside and outside of the house. To put the pub, yeah. Okay.
And most of them are coming from staff of the public house or the alarm system.
So do you have a total number from when did we start? May 24 to, let's say, well, to current time, total number of calls, total number from the borough.
So total number of calls is
40 earlier.
we did is 77.
Total is
So
77.
77 from
And bar SIA or Verishaw, do you have a total number of that 77?
would you give me just a moment?
Sure. More questions? Probably.
It depends how these bits go.
Right here.
Don't tell them the answer first though. Got to reach it independently.
You're ahead of me. Help me.
No, you go get by yourself. Show your working, please.
I've lost my February figures. No, I haven't. There they go. 8, sure. March, 2,
Right, coming in as evidence, so.
July.
Got the countdown music.
3, 4, 5.
I have a physics degree, so I'm not going to do that. Right. We're going to an answer. That's your subtotal.
I've got 34.
34. Okay. I won't take that as definite. 38. You've got 38. You've got 34. I won't take that.
Say between 34 and 38. don't
Oh,
you say?
yeah. I'll say between 30 and 40 have come from the bar. That's approximately or the bar, Verisco or security, that's approximately give or take half, but 40 to 50% of the calls. Right. Councillor Costa, do you have any further questions? And then we're going to move to summing up.
No, because I think I'm happy with my questions.
Okay.
Yeah.
We will not be hearing from the licence holder as they've recused themselves, so I'm going to request each party to sum up. We will do reverse order, so if that's the correct way, reverse order is a particular determination of its chair's discretion.
Yeah, if you, I think what I recommend is probably take the
Supporters and then,
first.
yeah. So I'll do reverse order, so police.
There's
summing up.
a Latin maxim, res ipsa loquitur, the thing speaks for itself. You couldn't have a case which was more overwhelmingly in favour of revocation. Please revoke.
Thank you, Councillor Small.
I have nothing further to add.
Thank you, Mr. Bellringer.
Yeah, so due to the number of complaints we received, the action that we've taken and tried to take, the Mr. Kearns dissolving of companies is really that. And obviously in line with residents who have been experiencing and reporting to us, and in line with the police's evidence, we are in full support of revocation.
Thank you very much. We will now bring the meeting to a close. We will remind me of the procedure. We'll be taking this to adjournment when we do close the meeting here, don't we?
Yeah.
We're going to make the decision. The decision will be determined today and communicated in writing within 5 working days. Thank you all. Safe journey, hands.
And I thank you on behalf of the police for having read the papers. You'd be astonished at how many committees we appear in front of who haven't taken the trouble.
Well, there's a lot.
Thank you, Chair. Thank you, committee.
Thank you, Councillor Small.